Right now, it's my pleasure to introduce James L. Haley. Hopefully, everybody's familiar with Jim Haley's work. Jim is the author of 18 books, but as he's reminded us, his last real working gig was as a Texas Capitol tour guide, working for Allie James, and hopefully you found some skeletons when you're working there. His next writing project was a Texas Supreme Court history, which is your most recent published book, correct? Oh, no? Okay. Well, that was what I was going to say next. You're working on a series, right now you're working on a series of fictional tall ship sailing Navy adventures, so you already have one out? Okay.
No, it's in the...
Okay. And a second one will be out soon. He is best known, though, for his biography of Sam Houston, which won 9 historical and literary awards. Please help me in welcoming Jim Haley to talk about Carpet Slippers and Flying Inkwells. Welcome, Jim.
Thank you, Mark. And thanks to James for making all the arrangements to get me here. Since you were kind enough to sort of introduce what I'm doing, a couple of people have already asked me, well, what are you working on now? And yeah, I got a gig. I got a 3-book contract with G.P. Putnam's Sons to do a series of early American tall ship sailing novel adventures on the theory that there has never been an American Horatio Hornblower. When I said I'm a novelist again, one professor friend of mine said, "Oh, you found your calling at last." When I first got a job to do a history of the state Supreme Court, the first one since 1917, and then I,
Gotta make it official.
oh, there we go. And then I found out that one history of the Supreme Court was basically capsule bios and case briefs. And I had this thing to do. I felt kind of like an old guy that I saw out at Hamilton's Pool. A friend and I went out there hiking. And when you go to Hamilton's Pool, you know, there's a trail that goes down to the Pedernales River. And so we went down this trail, and there's an older couple walking along the riverbank. This guy was kind of uncomfortable and just, didn't really... Well, he finally walked out into the Pedernales River about knee-deep, and he sat down. His back upstream, his feet downstream. And a second or two, he said, "Oh, yeah. Oh, boy. God damn, yeah." And his mortified wife said, "Harbert, what are you doing out there?" And he said, "That rock's been there millions of years without moving. I moved it." So I've had this opportunity to do something that had never been done before, and also at least have a great deal of at least intellectual relief. Now, I'm told that there are special announcements to come after I'm finished. In fact, James emailed me during the week. It would be really great if I could cut things a little short because they were sort of last-minute announcements. And so I referred him to a website where he could purchase Biblical Reenactor Shepherd's Crook for $5.95 plus shipping. So if I get to my expiration point and I get yanked from the podium, you'll know that he actually went out and bought one. So I'm going to talk fast. In fact, when I had my last paying gig as a Capitol tour guide, the last tour that I gave was a group of seniors from South Carolina, and the bus was late, and they all had to go to the bathroom, and then they made their way upstairs. They still wanted to hear everything, so I was giving it a good effort. And finally, this lady said, "Oh, honey, slow down. We are from South Carolina. I don't think we can even listen that fast." In fact, I'd better do this. I'm going to take my watch off. Now, many of you know that I was raised Church of Christ, and where I used to go to church, the little old lady said, "Now, when that new preacher shows up and he takes off his watch and he lays it on the pulpit so he doesn't go long, you need to watch out for him. He's probably a liberal." Now, living in Austin, okay, I'm going to put this in a place where I'm not going to be brushing it all the time. You know who I am. I don't need that. Living in Austin, we see here probably more of the state government in action than people elsewhere around the state would or would want to. And I've been reminded of the wisdom of Bismarck, who said that laws are like sausages, you're better off not knowing how they're made. In fact, I looked that up because I wanted to be accurate, and I was astonished at the cruel truth of many of Bismarck's observations, such as people never lie so much as after a hunt, during a war, or before an election. Smart man. He also said there is a providence that protects idiots, drunkards, children, and the United States. Well, here in Texas, of course, the legislative branch and the executive branch pretty much hog the spotlight. That's really all we ever hear about in the news. And political commentary all functions around them. And so we kind of pass over the Texas judiciary. We know that there's a Supreme Court, and they're called upon to do their job. But, you know, they're not really that big a part of the news, right? Yet the Texas courts have every bit the history, and I think more compelling and more interesting in history than the other branches of the state government. There we are. It's a mold spores thing. Austin, as much as I love living here, is the allergy capital of the world. Don't worry, I'm not going to gargle in front of you. Now, to understand the Texas Supreme Court in the 19th century, we need to briefly back up a few centuries to understand what a unique heritage we have in Texas law. Now, in the evolution of Western civilization, we came up with two mighty systems of law. The first was the civil law, beginning in Rome more than 2,000 years ago, preserved in the Mediterranean countries to this day. Now, the civil system is rooted in codes of law that try to foresee all these circumstances and conflicts and issues that might arise and deal with them preemptively. The other one is the English common law from Northern Europe, and that developed, how should I say, based on their experience. You decide an issue comes up, you decide it based on what other cases have happened in the past, not looking forward, but looking to the past. So there's fundamental differences between these two different systems of law. The English common law being experientially based, that's not just it. It comes out of a different culture, a different geography. For instance, look at water law. In England, it rains all the time. So when you bought land, you just understood that you get the water that's on the land, under the land, around the land. Spain is semi-arid. And so in their system, you developed a law that says when you buy the land, you don't get the water unless you contract for it separately and you pay for it separately. Now, the civil law took a very interesting turn in the 15th century, and I think she's seminally important. In fact, I give this talk called 10 Tall Texans you probably never heard of. I would probably include her, although she never heard of Texas, and that is Queen Isabella of Castile. 1492, Columbus sailed the ocean blue, you know, that Isabella. She was a paradigmatic, strong woman. Her father did her wrong. She was kind of pawned off to this prince and that one for his political advantage. Suitors that were foisted off on her died under mysterious circumstances. She wound up picking her own husband in Ferdinand of Aragon. In fact, she squeezed a prenup out of him. And she did not take a crown matrimonial. In fact, that was their motto, tanto monte, monte tanto, equal power, equal state. Their decrees had to be joint. And so a large part of the turn of the Spanish branch of civil law is thanks to her. In fact, it was a joint decree of theirs, I think it was in 1498, about debt, debtors and creditor law, saying that, well, if you owe money, you have to pay it, but they can't come take everything you have. That was not meant to be as kind as it actually sounds because it had to do with expelling the Jews. But under the common law, they had debtor's prison. You can't pay it, we'll lock you up until you figure out a way to pay it. So there were ways in which the civil law was vastly different from what developed in England. one of the greatest differences between the Spanish civil law and English common law had to do with the status of women. And this really is rooted in Isabella. In the English common law, and then in America, because we adopted the common law, girls belong to their fathers. When they got married, they belonged to their husbands. When a woman got married, her property became his property. Now, that wasn't true in Spain and in the Spanish Empire. In Spain, women could own and inherit property. They could manage their property. They had a much larger legal presence before the law. We saw that in New Spain and then later in New Mexico. One case I like to think of is Rosa Maria Hinojosa de Bailly. She married well, she inherited well, but because she was a woman, she could inherit. And her family were grandees, so they had first choice in picking their land grants. But after she was orphaned and then widowed, she became Texas' first cattle queen. She wound up owning Padre Island, you know, that whole suit between the King Ranch and the Bailly descendants. She wound up, by the time she died, she owned more than 1 million acres. That and ran it, you know, had a grip on it. And so that was what life was like. At the time that American colonists began coming here, there were women, American women, who came in Austin's Old 300 as heads of families, which staying in the United States was pretty well unthinkable. One case I like to point to was Obedience Fort Smith. Fort was her maiden name. It's not like she was named for Fort Smith, Arkansas. You know, she had been Obedience Fort, and she married a guy named Smith. Anyway, she was the widow of an American Revolutionary War veteran. She had 11 grown children. She was in her 60s. She got in a wagon and she came to Texas because she could. By the way, she took her land grant in what became downtown Houston. So she wound up doing very well for herself. Other people came to Texas to escape debt. If you lived in Alabama or Tennessee, if you had it made there, you stayed there. You know, people came to Texas looking for a do-over, right? And Spanish law and then Mexican law, American creditors couldn't come get you. I mean, why did Moses Austin even begin this whole enterprise? It's because he'd been ruined in the Panic of 1819. Now, of all the issues that caused dissatisfaction among the American colonists with Mexico, that wasn't, those worked fine. The weak point of the Spanish system, the civil law system, lay in criminal justice. Because common law developed the idea of impartial judges, having your case heard by a jury of your peers. This is what the American colonists grew up with. The civil law system, the judge was also pretty much the prosecutor, and he'd already decided you were guilty or you wouldn't be in court, and you were presumed to be guilty unless you could prove yourself innocent, and that really didn't sit well with people who had come from the United States. So in that particular instance, the common law was vastly superior to the civil law. Well, when we had the revolution and we became an independent republic, there was a wide sentiment to do away with everything to do with Spanish law, Mexican law. We've had it with these people. We're going to be part of the United States anyway, and so we're going to make this big switch to the common law. Well, it didn't really work out that way. First, because everybody assumed that we would join the United States and be annexed right after the revolution, and it didn't happen. No matter how much Andrew Jackson wanted us in the Union, he couldn't make it happen because the balance in the American Senate between slave states and free states had been very carefully balanced ever since the Compromise of 1820, and to admit Texas as a slave state would have thrown that apple cart right on its side. So we wound up having to be our own country, trying to get annexed for 2 months short of 10 years. And when the Texas courts filtered this in, they said, okay, what we need to do is figure out what is going to work in Texas, because we had our choice. We have judges here who know what a case of first impression is. That's an issue that has never been before the court before, and so you get to, well, you look at the law and you look at what cases there are, but you're more free to decide what to do than you would be if there's a long string of cases that says you need to decide it this way. Well, now, there's a very seminal figure in the early Texas Supreme Court, John Hemphill. He was from South Carolina. He was not just a preacher's kid, but he was the son of a preacher and a preacher's daughter. He was estranged from his family in South Carolina. Very smart guy. He graduated number 2 in his class from Jefferson College in Pennsylvania. His big skill was languages. And so when he came to Texas, which was, being a Southerner in those days, you had to have some military pretension. So he had been fighting Seminoles in Florida and got malaria and then came west to clear his lungs out. So he came here and saw, the legal layout. He became this massive expert in Spanish law. Well, he began his career as a judge here. In fact, he was at the Council House fight when the Comanche chiefs, the whole Matilda Lockhart thing, there's this big fight and butchery. And he wound up getting in a hand-to-hand with a Comanche chief and gutting him with a Bowie knife, which was, he was distraught about this. I had to do it. He was going to kill me. I mean, none of this, I killed an Indian, I'm always reminded of Ed Burleson, who ran for vice president of Texas on the platform that I've killed more Mexicans and Indians than anybody else. Hemphill had entirely the opposite frame of mind. Well, it was under Hemphill who became Chief Justice in 1840, finished out the Republic, and then remained Chief Justice of the early state Supreme Court until he went to the Senate, I think it was in 1858. And he had a very strong view that when cases come up to the Texas Supreme Court, we're going to go our own way. One great way he did this was in the matter of pleadings. How do you get a case into court? In the early days of Spanish settlement, in fact, it began with the Canary Islanders, they'd been promised, you will be hidalgos, you will be nobles when you get to Texas. That's why they went to the Canary Islands west of Africa, because they had no idea what was waiting for them in Texas. And they got here, and boy, were they upset to discover they're in this raw wilderness, and they start suing each other, only there's no courts, So you got to have some way to get into court. So they turned to the town secretary, Francisco de Arocha. The legend was that he got the job because he had the prettiest handwriting. And he said, okay, how am I going to figure this out? Okay, who are you? What happened to you? Who did it? What do you want us to do about it? That's it. You fill that out. They go to the guy that you're pointing the finger at, and he makes an answer, and you're in court. The common law developed at least 8 different stages of pleadings to get into a court, and a mistake in any one of these stages, you'd lose your case before it ever got to the merits. Well, after we're independent, here comes all these American lawyers just saddlebagging it into Texas, going, boy, we're going to eat those hicks for lunch, because they knew how to win a case before you found out you were really had no case. You could defeat somebody on the merits. And it was Hemphill who repeatedly said, no, Spanish pleading makes more sense for us. We're going to keep it. You need to, if you need to learn Spanish, then by golly, you need to learn Spanish. But you're not going to pull these American tricks of sophistry in Texas courts. It's just not going to happen. Well, he got his way on that issue, but some of the other justices, he began sort of strong-arming on these topics. One of whom, Abner Lipscomb, he'd been on the Alabama Supreme Court for 12 years. He didn't feel like anybody's weak sister. But Hemphill really made the Spanish way of doing things stick. Now, the position of women in Texas under Spain and then Mexico was so solid, that wasn't really questioned for, at least a generation. But how should I explain this? Remember Seneca Falls, 1848? When the ladies all got together as the first feminist political rights for ladies suffragist meeting. And they published a declaration at the end of this thing saying, hailing New York State. Thank God for New York. They've given us community property rights. They've liberated us from marriage slavery. They knew perfectly well that Texas had entered the Union 3 years before with community property protection for women. They just didn't want to give that credit to a southern state. It's called a lie, okay? In fact, the New York legislature had debated community property rights for women the year after Texas entered the Union, and they looked at the Texas Constitution as their guide, and they voted it down. 2 years later, they thought better of it. But I'll tell you what, Sam Houston knew about this, and it was one of his selling points. You know, during his Senate years, from 1846 to 1857, 13 years, anyway. Before he would, on his way from Texas to Washington, he would go on a lecture tour every winter up the Ohio Valley, New York, Pennsylvania, New England. And he wasn't running for president. He was just sort of increasing his visibility so that people would know that he's available for president. And he would give these Chautauqua talks, right? And in 1851, here's one he gave at the Music Fund Hall in Philadelphia. And he's talking about women and their advantages in Texas. And he said, I'll tell you what it is. Texas was the very first state that took up the great subject of homestead protection to the ladies. Our laws are that if a lady marries, her husband has no control, without her consent, over her estate. He cannot dispose of any portion of it, nor can it be taken for the satisfaction of his debts, incurred either before or after the marriage. And if he dies owning the whole estate and she owns nothing, she has her homestead and farms and improvements protected to the amount of 200 acres or $2,000 that cannot be attached. Now, if you can beat that, I'll give up. You know, so there were other matters on which the Texas Supreme Court went its own way, one of which was in criminal law, because that's a place where we did adopt the common law. But for years, everything was a case of first impression. There was one murderer named Jones who was convicted, and he appealed his case to the Supreme Court purely on the issue that, well, I had more witnesses than the prosecution. Therefore, I went. And Abner Lipscomb, wrote this elegant opinion saying, well, that's not really the way it's going to work in Texas. It's not going to depend on how many witnesses you have. It's what did they say and how credible are they? They did overturn his conviction, though. They said that it was reversible error for the bailiff to have been giving whiskey to the jury while they were deliberating. True story. Now, I'll bet you didn't know, and this is one of the most fascinating things about the 19th century Texas Supreme Court, was that we had great conflicts with Mexico over slavery. And of course, Mexico never could really decide because the state government of Coahuila y Tejas was interpreting the law more leniently to show their opposition to the centralist government, and we were constantly, wiggling ways around the Mexican prohibition on slavery. But the Texas courts were by far the most liberal in the South in terms of letting slaves into court where they had no right to be, letting free persons of color into court where they couldn't be unless they were accompanied by a white person to vouch for them. And you even had cases where slaves sued for their freedom and won. I mean, this is part of Texas judicial history that almost nobody knows. There's a fascinating case of Guest versus Lubbock. There was a guy named Adam Smith, not that Adam Smith, who came into Texas with a slave named Margaret with whom he had a daughter. He gave her freedom. They had, like I said, a daughter together. He gave her freedom, and then he died. Well, his nephew, who happened to be Frank Lubbock, who became governor, sued the estate to get Margaret and her daughter to be his slaves, which meant that he was suing for ownership of his own cousin, but never mind. Margaret contested this, and the Supreme Court of this southern state said, well, yes, her manumission document should have had 5 signatures, and it only has 1. But it's perfectly clear that Adam Smith meant to free her, so she's free. Period. Go away. Talk about your runaway liberal activist judges. I shouldn't have said that. I'm sorry. So she got out of Dodge while the going was good. Margaret disappears from history. There were other cases. In fact, in 1858, Texas made it legal for a free person of color to sell himself into slavery if he needed money. There were safeguards. You had to have so many witnesses saying that, yes, he's doing this of his own free will, and different safeguards. Well, there's a guy, it was up in Johnson County, south of Dallas, a guy named Louis John Red Rolls. who had come as a free black with the family he worked for from Mississippi. He needed money. He sold himself to the owner for $2,500. Now, mind you, all kinds of things can happen that these slaves would never actually see the money. Oh, we're going to charge you for room and board. We're going to put this in escrow because you don't really have sense enough to manage your own money. And a lot of times they'd sell themselves into slavery and never see the money. Well, Red Rolls, 2 years later, sold himself into slavery to a guy a couple of counties over and disappeared. Well, these two white families found each other, and oaths were exchanged, and pistols were drawn, and it all went to court. And the Texas Supreme Court said, you know what, if Louis John Red Rolls was smart enough to know that that first sale wasn't enforceable, that's hard cheese. He belongs to the second guy. Actually, he sold himself to the second guy because he owned the mother of his two children. And he was trying to keep his family together. And he was able to do it. Yeah, the Texas Supreme Court did a number of things. Now, I think that a large part of why they could do this had to do with Judge Hemphill. Hemphill was estranged from his family in South Carolina. He did have a long-time relationship with a slave named Sabina, with whom he had two children, Theodora and Henrietta. Now, I know that in politically correct history, slaves are legally incompetent to give their consent to a relationship. Therefore, it's always rape, and so on and so on. But I want you to consider for a minute that Hemphill, in his relationship with Sabina, he couldn't free her because that had become illegal, and he couldn't, he couldn't marry her because that was illegal, and he couldn't free her because then she could have been kidnapped and sold to somebody else. So this little off-the-books relationship that he had with her was the best protection she could have. So yeah, slaves were legally incompetent to consent to a relationship, but this is as good as it got for somebody like Sabina. Hemphill did put his two daughters into Wilberforce University in Ohio, which A, got them out of the South, B, got them educated. William Wilberforce, the guy in the British Empire that fought slavery. Well, actually, most of the student body of Wilberforce University was mixed-race children of Southern white planters. That was the whole business model for Wilberforce University. By the way, the Texas Supreme Court Historical Society, who published my history of the Supreme Court, has a board member named David Furlow who has written a witheringly brilliant article about Theodora and her legal position as it changed under the different constitutions. And I want you to know that that article is freely available on the Historical Society's website, which is, pencils ready, www.texascourthistory.org. You will see a pull-down menu of publications. Go down to Journal and click it, and you will see what a wonderful series of publications they have done in their journal. So, the Texas Supreme Court established early this history. Oh gosh, time flies. I've been accused when I stand up to talk about history, I'll keep you here till like next weekend. It's quite true. They established early this history of going their own way. And one of my very favorite people is James Hall Bell. He was an associate justice in the 1850s. Now, I want you to notice that I have not brought PowerPoints and slides and all that deliberately, not just because Allie already showed a picture of the courtroom, but because I want you to go there. When I was a tour guide, if I was working the early shift, first job is you get the key to the Supreme Court room, you go up to the third floor and you open it and you prop the doors open for people to come visit. And I want you to know that courtroom, well, we'll get to the courtroom in a minute, it is something. Anyway, James Hall Bell was the first Harvard man on the Texas Supreme Court. He was also the first native-born Texan on the Supreme Court. When Stephen F. Austin first came into Texas to see about maybe starting a colony, he found a guy named Josiah Bell, who had been in the militia in Missouri, squatting in the woods near Nacogdoches, right, with his family. And James Hall Bell was a babe in arms. So he's one of the very first white babies born in Texas. Went to Harvard, studied under Joseph Story. I mean, you know these big horn books, Story on the Constitution. The guy who's on the U.S. Supreme Court all those years, that's Judge Story, who was his teacher. Well, James Hall Bell, like Sam Houston, was a Unionist. And he opposed the coming secession and Civil War. In fact, when the secession convention met and pulled us out of the Union, they had to have a referendum, right? And we all know that that referendum passed. I wrote this down somewhere. It was like 46,153 for, 14,747 against. So basically 46 to 14, let's pull out of the Union. James Hall Bell went home to Brazoria County to vote in the secession referendum. And he went up to the polling place and they gave him a bright pink piece of cardboard that was pre-printed for secession. And he asked for a pen. They gave him a pen. He propped his leg up on a chair and he very carefully scratched out for and he wrote in against. An armed poll watcher said, "Judge Bell, I'm real sorry to see you do that. You're going to regret it." And we wonder why secession passed. I mean, what nerve for those 14,747 to vote against it? We forget there was a lot of Unionist strength in Texas right up until the shooting started. And by the time the shooting started, there were already vigilante mobs running around, lynching people, throwing them into dead man's holes and burning out their farms to make sure that they would support secession. James Hall Bell also voted, a big case came up, ex parte Copeland, challenging the authority of the Confederate government to draft people. And he voted, it was 2-1, and it was a very close decision. In fact, it only decided in favor of the Confederate government's conscription only because of the emergency of the war. And Bell wrote this hot dissent. I mean, Ruth Bader Ginsburg never gave a hotter dissent from the bench, saying, well, you know what? We managed to fight the Revolution and the War of 1812 and every other scrape we've been into, we managed to do with volunteers. And the majority opinion, even just to give him a little tweak, quoted Justice Story on the Constitution for the authority of the government to draft people. Oh, that really made him mad. And in turn, I mean, you could almost hear him, looking at the Chief Justice saying, "I know Judge Story. Judge Story is my friend. You are no Joseph Story." He turned around and quoted John C. Calhoun on the lack of authority of a government to draft people. So he's kind of a hero of mine, but very much in the mold of the Texas judiciary going its own way. Time flies. We're going to go through pass over the Supreme Court and during the Civil War and Reconstruction, the Semicolon Court. It's a fascinating history. It's all in my book. Although you'll have to buy it in paperback now because UT Press printed like 3,000 hardbacks. They sold out in 2 months. There's 80,000 lawyers in Texas. I mean, it kind of went. And you thought they would have printed more books, but it went to paperback print on demand, which they charge the same price for as the hardback books, and I don't do that. So, but find one, and that whole story's in there. All right. The Consensus Court. When they opened the Capitol in 1888, there's this gorgeous courtroom. And as Allie pointed out, it was fitted for gas because the construction people thought that electricity was just a passing fad. But there was a direct current generator on the Capitol grounds. So these wires will never last. So they just hung wire from switch, over the wall and light bulb. And there was a 2-bladed ceiling fan to keep the judges reasonably cool. There were red windowsills of Etowah marble from Georgia. The radiator grills were plated in 14-karat gold. When they did the restoration, they kind of throttled back on that. There was Wilton woolen carpet that was sort of a brown and cream color. The loom had a jacquard attachment, so it's this gorgeous floral pattern in 27-inch strips that was hand-sewn on the site so that it looks totally seamless. Oh, and by the way, the bench, which was later sawn up and split so they could fit 9 judges along it. Well, back then there's only 3 judges. And the motto in gold letters said, Sicut Patribus Siteus Nobis, which many, many years was translated as, as he was to our fathers, so may God be to us. In 1902, they hired a clerk who spoke Latin, who said, no, Sicut Patribus Siteus Nobis, as our fathers did, God will do to us. Different narrative. Different narrative. Okay. Now, at some point, each and every one of you needs to go up there and see this. It's lined with portraits of all these wonderful judges from back then. The restoration job is just impeccable. It's just, some of it's original. The walnut curtain rod is original. Now, the gold Brocatelle back fabric behind the bench is a reproduction. But they found swatches of the original and rewove it exactly, just as they did with the Wilton carpet. Now, I'm surprised that carpet wore out, because about the same time that they opened the Capitol and the Supreme Court goes in there, one of the junior associate justices, Reuben Reed Gaines, we're going to talk a lot about him in the next few minutes. Reuben Reed Gaines stopped and had the porter bring him carpet slippers, because he did not want to wear street shoes on this elegant carpet. Now, the porter, Alex Phillips, was there for like 110 years. I mean, there's a lot of stories about Alex the porter. I won't have a chance to do this later, so I'm going to work it in right now. When they moved the court over to the new building in 1959, still there, and one of the clerks came in to get his stuff, and it was at night, and he came in the old courtroom, turned on the light, and old Alex was just sitting in the old courtroom in the dark. He says, "Alex, what are you doing here?" And in his memoir, which is written up, he did this in dialect. I'm not doing this in dialect. He said, "Alex, what are you doing here?" He says, "Oh, I was just visiting with Judge Gaines, Judge Brown. They left when you opened the door." Which, in giving the Halloween tour, I like to tell that story. About the only ghost story for the Supreme Court room. Now, the court at that time had kind of a different view of things. You have to remember, we have 100 years of cases and precedents now for the judges to be guided by. But back then, they felt a lot freer to decide a case, as they said, in equity. The Supreme Court, any appellate court, okay, they interpret the law, but this whole business about, oh, judges don't make law. Judges, just limit themselves. I'm sorry, that's a Fox News thing. Judges have two jobs to do. One is to interpret the law. The other is to provide justice for the case that's in front of them. And back then, with a lot less case law to guide them, they felt a lot freer to do that. And boy, did they. Oh, by the way, at the end of every day, Alex would bring Judge Gaines his street shoes. And after there were telephones, Gaines eventually got okay with this, and he would tell this story on himself. But he had the most faultless judicial demeanor. He was quite a guy. He had fought through the Civil War from first to last under Joe Johnston, which, if you know your Civil War, means that he's one of those few guys who never surrendered. He had been involved in politics, but from the day he became a judge, he had nothing to do with politics. He was famous for his impartiality, for his scholarliness, for his judicial temperament. Well, there was that time he chased the waiter out of the hotel of the Driscoll with a carving knife. But he was prone to rages if he was surprised by something. In fact, if an opposing idea came up in chambers, he was known to throw an inkwell at it. And so the other two justices would scurry away from their chambers. Oddly enough, the only person who could control Judge Gaines in one of his rages was Alex, the porter, who would creak open the door and say, "Judge, if you's through with your tantrum, I'll call the other judges back and pick up." And he was usually better. But by the end of the day, he would call up Weed's stable on the telephone to have his buggy brought around it for 5:15. The phone number was 223. And then he would go for a drive around the city, usually with one of the clerks or two of the clerks to keep him company. And then he would repair to this place where he would watch the clerks. They liked to play pool together, until late in the evening. He never played, but he would always watch them. Well, now he and his wife Louisa were living in rooms in the McDonald building. And, Louisa got to where she was kind of resenting being left alone every night, which, she never really let on until one evening Justice Gaines came home and his door was locked. And he knocked on it. And from inside, he heard his wife say, "Is that you, John?" "Who the hell is John?" he was he was more attentive after that. Now, going into the 20th century, this is what they call the consensus court. There was Judge Gaines and had two real buddies there. One was Thomas Jefferson Brown. Now, he was completely different. Judge Gaines was wet. Judge Brown was a teetotaler, a very strict Christian. He believed in a Spartan existence. He believed in a cold bath and a walk before breakfast. He loved politics. He was a fiery stump speaker. He was a progressive. He corresponded back and forth with E.M. House, if you remember Colonel House. And then there was Frank Alvin Williams. There was Frank Alvin Williams. His big complaint was that they don't pay judges enough, so he eventually quit and took a private job. But some of the cases they decided, we'd been a state by then for over 60 years, and so here came lawyers trying to carve into women's rights, which I've got this. I want to find this quote before he comes out with the shepherd's crook. Oh, by the way, Judge Brown liked to take a walk every night. And he had a lamp that he hung on a shepherd's crook. And he was quite elderly, and he would walk. It's kind of like Diogenes looking for an honest man. But Clerk Clamp would discreetly walk behind him to make sure that he didn't get flattened by a Tin Lizzie. During the day, he would walk. His house was at 14th and Colorado, and he would walk all the way up to the insane asylum and chat with the crazy people. Now, I know that's not politically correct, but you have to remember in Austin at this time, one of the most lively entertainments on Sunday afternoons was to pack up your picnic lunch, drive out to the asylum, spread out your picnic, and watch crazy people. That's what they did. But one of the cases that they decided, and I remember this one particularly, and since I'm running out of time, okay, I'm going to tell you two more things before I sit down. The way they would do their work is that Judge Gaines would read the holding from down below. Actually, he kind of scholarly mumbled it. Well, Judge Brown was hard of hearing, so Clerk Clamp would, whatever Judge Gaines read, Clamp would yell into Judge Brown's hearing aid. He had an acousticon hearing trumpet, so it was like, "In the holding below," sort of like if you remember Garrett Morris in the first Saturday Night Live. And they would decide whether they were going to hear the case or not. But one case in particular, and you can take this as a paradigm for the way they ran their courtroom, the case of Doherty versus Doherty. There was a lout and cad of a husband who married this woman and lived off what she brought to the marriage. Now, if she'd been on her own, she would have been fine. But a woman, when she got married, the husband did control her estate. And so she was kind of a sickly woman, and she had to support herself on her butter and egg money while he rented out her ranch and lived high on that. Well, she put up with this for 25 years, and she divorced him. Well, the lower court said, well, he may be an SOB, but there's no grounds for divorce here. Appealed it to the Supreme Court, and it was Frank Alvin Williams who said, and he cited cases, well, yeah, she really does get to divorce this guy. Now, the cases that we cite may not wholly apply to a case like this, but they do affirm the principle that a husband's right to control the wife's property during marriage, quote, is dependent upon the discharge of duties that go hand in hand with that right. Now, I think it was in 1912 or 1914, women got the right from the legislature to control their own property that they brought into the marriage, but not at this time. There again, the activist liberal judge. There was another place where it was Hatcher versus Range, which established slander on the same footing as libel, that if you just say something bad about a woman, but she's not really damaged by it, that's still actionable. And it was T.J. Brown who wrote that, this is against the precedents. We are reluctant to follow precedents so unreasonable and unjust. But we're bound by those precedents unless there be present in this case a sound reason they should be disregarded. And so they did. And this is a time when the whole doctrine of attractive nuisance, that you have to keep your property safe from straying children because a child doesn't know about trespass, that had not been the law until the Texas Supreme Court made it the law. There's no statutory justification for it. They just said this is the right thing to do. And okay, I will yield the balance of my time for those extra announcements. If you can find one of those books, and I know it's a collector item now, you can find it in the used and rare sections of the internet. No, it's still in paperback from UT Press. So if you have as much fun reading it as I did writing it, you will have a good time. And I thank you for your attention. Oh, questions, yeah.
Want to take a
Yeah.
2 or 3 questions?
Yeah, shoot. Pop quiz.
Two or
Except for
3
Judge
questions?
Phillips back there. He doesn't get to ask.
Did Judge Bill take the oath to the Confederacy?
Did Judge Bell take the oath to the Confederacy that caused Sam Houston to be impeached?
He was defeated when he ran for re-election to the court. I think it was in 1858, 56 or 58. He was defeated and was replaced by John William Staton. So he never had to take the oath because he was booted out for being a Unionist.
Any others?
Wait, microphone.
What is the name of your book?
The Texas Supreme Court. A narrative history, 1836, 1986.
And where is it for sale?
UT Press.
Yeah.
Yeah. And
Are we done?
I think that's all.
All right, thank you very much.